A court appointee named Dr. John Palen accidentally copied me on an email that I believe was a solicitation of bribery. I have made exhaustive efforts to try to find the reason for the email and taken other actions to ask parties involved, including Judge Johnson's own scheduler, Kay Mason, which is to say Judge Johnson himself. And instead of providing an explanation or stopping any misconduct, Judge Johnson has punished me for asking why. In this video, I'm first going to describe how I came to have Dr. John Palen appointed in my case and what his role is in the Circuit Court of Cook County. Second, I'm going to talk about the problematic email and how it came to my attention and the questions it raised at the time. Third, I'm going to talk about Judge Robert Johnson, the trial judge's participation in the ex parte email thread with Dr. John Palen, in which what I believe was a solicitation of bribery took place. Then, because I believe it's related to a culture of misconduct and callousness towards my children, I'm going to talk about Dr. John Palen's direct involvement in a fraud scheme with my ex-husband, Peter Matt, perpetuated against our disabled minor child, who I'm calling A. And then fifth, I'm going to talk about Judge Robert Johnson's continued support of Peter Matt's fraud scheme, John Palen's actions, and misconduct by others that I believe continue to result in the exploitation of my minor son. And then finally, I'm going to discuss how I believe this fraud scheme against my minor son is related to potential kickbacks and bribes for other individuals in this case. I first met Dr. John Palen in or around October 2020. He had been appointed as a parenting coordinator by Judge Robert Johnson. I'm not sure what the basis was. I wasn't consulted before he was appointed. Dr. John Palen is a psychiatrist, and he's approved as both a custody evaluator and a parenting coordinator. It was in the latter role that he served in our case. And as a parenting coordinator, per court order, I was required to consult with him on all parenting decisions, particularly if there was any controversy between my ex-husband, Peter Matt, and myself about parenting decisions. And I was required by court order to pay him a $1,000 retainer, and Peter Matt also paid him $1,000, so he had $2,000 in around October or November of 2020. And he was then allowed to bill us at $250 an hour. Around December 5th, 2020, I was accidentally copied on an email from Dr. John Palen to my ex-husband's attorney, Christopher Werman, the court-appointed guardian ad litem, Michael Bender, and Judge Johnson himself by means of his clerk, Kay Mason. From what I've understood, even going back when people handed paper notes, when you are talking to the clerk of a judge, it is as if you're talking to the judge, his or herself, because most judges don't email, so you have to email the clerk. The reason this email was troubling was first that it was a secret thread, and it was an ex parte thread, which means that all of the parties, specifically opposing counsel, my ex-husband's attorney, had the opportunity to talk to the judge and other court appointees without me being included in the conversation. And that's forbidden, and it's called ex parte. I only happened to receive the email in question because I share the same last name, Mason, as Judge Johnson's clerk, Kay Mason. The second troubling aspect was the content of the email. The email was from Dr. John Palen, apparently mid-reply because it had no context, and he wrote, "I want to be paid. It is as simple as that." At this time, Dr. John Palen had a large positive retainer balance. There was no controversy over fees at that time, and there was no official action. If there were a controversy over fees, for example, you would expect him to have filed a motion to order fees paid. Nothing like that happened because he was not short of legitimate payment, which makes me think his request was for illegitimate payment. And as I'll detail a little bit more, I've made exhaustive efforts to ask every individual in this email thread or related to this email thread to explain to me why he said he wanted to be paid, or and specifically to provide the rest of the emails, because I knew it to be an ongoing conversation, and all have refused. At the time, Dr. John Palen swiftly lied and wrote, "Sorry, I had not noticed, Miss Mason." I think he meant Megan Mason, not Kay Mason. This email was meant for another case. The subject of the email was my married name and case number. All of the parties were involved in my case. I don't think that's true. And other parties later on have confirmed that there are more emails in this thread. So it wasn't an accidental email from another case. I was accidentally copied on an ex parte ongoing conversation, which is strictly forbidden. Since that time, I've truly made every effort to find out why Dr. John Palen said this, if it wasn't a solicitation of bribery, if he needed to be paid back because they all went bowling or something. That's something that should have been explained to me 2 years ago, or 3 years ago at this point, and parties still refuse. I also have attempted to subpoena the remaining emails from every party involved, including Kay Mason, Judge Johnson's scheduler. And being a court employee, I believe that anything she wrote on a server owned by the people of Illinois and the content of it, she has no expectation or right to an expectation of privacy, and she has really no right to hide those emails. And so I attempted to send a subpoena to attorney for the circuit court, Brianna Steger, and that was ignored. But Judge Johnson, actually Kay Mason, ordered me to come to court. There was no scheduled date. And I appeared after I had attempted to subpoena the emails in the winter of 2022. I appeared before Judge Robert Johnson in around March 2022. And he told me the reason I called you in here is because you can't subpoena my clerk. And I explained, as I just stated, that I didn't believe she had a right to privacy and that those emails are owned by the people of Illinois and it's about my case and that I should see them. I also reiterated what I know to be the Illinois Code of Judicial Conduct 2.9, I believe, which requires that ex parte communications shouldn't happen. And when they happen, if it's an emergency scheduling matter, as soon as possible, the judge is supposed to let the party who was excluded know what the conversation was about. In this case, that would entail forwarding the emails. But Judge Johnson has not followed the rules in this regard, and he said to me at this March court appearance, "I've looked at the rest of the emails. They're fine. You don't need to see them." So by Judge Johnson's statements, I understand that, one, he's participating in this ex parte thread directly, though again, I believe he was participating when Kay Mason was participating. Two, there is an ex parte thread because he used the plural and said, "I looked at the emails." And three, he's refusing to comply with the rules and send me the ex parte communications. This is problematic. And again, because of the nature, which sounds an awful lot like a solicitation of bribery, it's something to which I believe I'm owed an explanation. And this has been one of the issues that directly in court filings or indirectly has been used by Judge Johnson to sanction me. So John Palen was appointed in October 2020. This problematic email came to my attention in December 2020. And it was really into the spring that I began to see more and more concerning behavior, particularly with regards to my ex-husband's obvious, well-known criminality, specifically actions to hide his financial crimes or directly participate in them. In around May of 2021, my ex-husband, Peter Matt, called a meeting. He said the reason for the meeting was with Dr. John Palen, the parenting coordinator, acting in that role. And it was to get John's help, according to Peter, to get Megan not to interfere with his new business idea. During this meeting, Peter explained what his new idea was, which was to name our son A, who was 13 at the time, and has severe developmental disabilities and does not consistently count to 10, to have him named as CEO of Peter's business. The purpose, he said, was so that his business could be certified as being owned by a disabled person and get contracts set aside for such businesses. During this meeting, I immediately voiced my objection for 2 reasons. First, I said, I believe that's fraud because A is not the CEO, and I believe it's wrong to involve our child in crime. I've since come to learn that it's actually a statutory form of child abuse in Illinois to use a child in a crime, which makes sense because it's disgusting. The second reason that I gave was that I was worried that when our son turns 18, he might lose access to disability benefits like Social Security, which he might normally be entitled to if he had a well-paying job. Dr. John Palen was in attendance on this Zoom meeting, and he said, I think that sounds like a great activity for A. Peter, you should make up a business plan. And so he was presented directly on behalf of the court to protect my son from being exploited criminally and financially, and he declined to do so and encouraged the scheme. I do have proof of this because subsequently Peter wrote an email, and the same email address that Dr. John Palen uses on his official court filings as official court parenting coordinator was copied. And as Peter said, subsequent to our meeting, following John's suggestion, he made up a business plan. In the email, Peter also said that he had found a way to address my concerns about A, losing his disability benefits, because Peter stated that once A turns 18, his shares, because the problem is, in order to be certified as a company owned by a disabled person, A would have to be the highest paid employee, as the CEO typically would be, and he would have to have the largest ownership. So what Peter said he would do is basically pretend to give the shares to A in order to defraud the other companies. And then when A turns 18, the shares he'll just steal them back. And he also did attach the business plan where he laid out in particularity how he also intended to keep A's salary, though, of course, to defraud companies, he would have to pretend he was paying him that salary. So to, from the start, steal his salary. And he put in the business plan that I was not to interfere in any way. And although I was married to Peter Matt for a decade, and during that time, he never wanted to take the time to create a will for himself, he did take the time to point out that if our healthy 13-year-old should die, then the shares would reverse to him. Judge Robert Johnson and Michael Bender have known about this fraud scheme for 2 years, and they've done nothing. Chief Judge of the Circuit Court, Timothy Evans, has known about this fraud scheme for months, and he does nothing. And there's sort of, there's just a standard operating procedure with the Circuit Court. If you ever raise issues with ethical violations or crimes by employees working there, they will immediately respond with immunity. There can't be immunity for crimes that exploit minor children, because a crime exploiting a minor child is not a legitimate judicial act. How could it be? But the modus operandi of Chief Judge Evans, and he's certainly been there a long time, so he's good at what he does, is to try really, really hard to pretend that he doesn't know what's going on, so that he doesn't have to ever say that a judge or court appointee has ever done anything wrong. So he cares nothing for children and does nothing for children, and yet he is the person tasked to prevent such crimes by his employees. The entire executive committee of the Circuit Court of Cook County has also been informed of this for months, including Judge Robert Balanoff, who's the presiding judge of the Child Protection Division. And I think he, of all people, should understand when a disabled child, is being exploited in really obvious ways. And maybe it needs to be done quietly. Heaven forbid we embarrass somebody, but they need to take action to stop this, because If you own a business and people are using the office that you own and the servers that you own to commit crimes, and you know about it, then you are participating in those crimes. And these gentlemen and everybody else on the executive committee knows all about this, and they are electing not to intervene. So from the time he was appointed, I felt that Michael Bender was bizarrely biased against me. For a long time, I tried to give him the benefit of the doubt, think maybe he's just a misogynist, maybe he just thinks I'm uppity, but he's not gonna go too far. He'll color within the lines to the extent that he wouldn't violate laws. But once he started seemingly to facilitate, hide, and coordinate with Peter Matt to commit these financial crimes, I became certain that he must be getting some sort of benefit through his involvement in our case. It just doesn't make sense to be an attorney and want to be associated with Peter Matt when you think about the business plan that I just presented. It's not something a rational person would normally do. But at first, I really couldn't figure out how he was getting any sort of kickback. For one thing, it's in this day and age with modern banking, it's hard to facilitate cash bribes, and Peter doesn't have like a jewelry business or something with a lot of cash floating around. In fact, he has a really hard time getting money from his assets in Europe because he moved them there to hide them from the IRS. And when you do that, it's hard to get the money back. You have to launder it. And so at first, just guardian abuse, which is a little different than a guardian ad litem, that rule had been in the cultural zeitgeist, particularly because of Britney Spears and the Free Britney movement. But also, I saw this movie on Netflix called I Care a Lot. And in it, I realized that in addition to the victim, who was an elderly woman, in addition to the exploitative guardian stealing her personal wealth, she was also stealing her entitlements, her benefits. And I realized that unlike most children who reach majority at 18, a child with severe developmental disabilities might expect to be a dependent for decades or for the rest of his natural life, and during that time receive regular entitlements. So at first I feared that maybe Michael Bender was angling to become appointed as a permanent guardian. Everyone told me that this is something that doesn't happen, that's crazy, but I think a lot of things that have happened are crazy. So I'm just looking for what makes sense. But then when this fraud scheme came along, I realized that it's our children in the form of trusts, business ownerships, LLCs, that are in our children's names by which Peter Matt can both move money from Europe here and also use the vehicles, say a special needs trust, to pay trustees, to pay guardians, to pay people exactly like Michael Bender. And so because of Michael Bender's vigorous actions to defend, allow, and seemingly encourage Peter Matt's exploitation of our son, I'm kind of thinking that these schemes are also benefiting him in very material ways, or he has been promised benefits in material ways. But again, if Michael Bender has another explanation for why he's participating in an ex parte email thread and won't give me the emails, and if he has another explanation for why he thinks it's okay for John Palen to be asking for payment in those emails, then he should explain that to me. And if Dr. John Palen wasn't asking for a bribe when he said, I want to be paid, it is as simple as that, he should explain to me what he was talking about. And at this point, I really don't understand why Dr. John Palen is still an approved court appointee. And I think Chief Judge Evans and the executive committee of the Circuit Court of Cook County owe me an explanation for that. So Dr. John Palen seems to have solicited a bribe. Judge Robert Johnson seems to have protected him and protected Peter Matt during this and other financial irregularities. I want to know why.